Not on there.
Nope.
Pardon.
Okay, so Ben, are you there? Ben, can you hear me? Hello, Ben.
There we go. All right, let's do it.
So we are not able to get a hold of Mr. Grady. Do you guys want to do closing arguments and then have him testify, or what do you want to do?
I mean,
It was a little backwards. I get that. That's why I'm.
no, it is backwards. I mean, given the time, I'm flexible Monday morning. I like a hole in the head. I want to do this later. I don't know. I'm saying I'm flexible, but at the same time, we're getting to diminishing returns here. So,
Well, no, and I don't think your client wants to spend the weekend in Milwaukee.
hey, many people like us, but I think we could do all that by Zoom. So I don't think that's. I mean, I think we'd be flexible on that. I don't think. I also think it's
so
half an hour. You can have her presence, whatever you want.
I don't want to dive into confidential ideas here, but is there anything of Mr. Grady that you would be asking him that you guys could just stipulate to?
I mean, I wrote down the 2 questions and we both had them, which was, you know, where's this video and what's up with the sheets?
Where's the, okay, so what video did he observe?
Right? What summary?
And the sheets.
Right, where did he hear about these sheets?
Right. Well, that's obviously not going to be something we can stipulate to unless we know.
Hey Dan, it's Max.
Hey, we might have him on the phone.
Are you gonna be able to come back in? We need a few more questions of it.
I got a pre-dis at 1 on Monday, but that's it.
No, I think we're going to get him here.
All right.
Yeah, would it be okay if he appears without video? Thanks.
It's fine.
Yeah, just calling in would be fine.
Does he have the phone number?
Okay. Sounds good, thanks.
Does he have the phone number?
Yeah.
Okay, he's coming in here.
It'll be a couple minutes.
I was in Madison. Okay, fine. We're gonna have to ask him now about the budget stuff. And the dog and the retirement. Yeah.
Also asking about the wage study and why the after Brian sent it into him, it was 21.
Is the clerk still here?
I'll go check.
Someone's gonna need to shut this thing down. I'd like for her to somehow share it so that everyone has it.
Well, there was a paper grant in my, doesn't come on the Monday, probably.
Okay,
And save it to a Dropbox, share it there.
you or her, I don't care who.
Yeah.
That's fine.
The county doesn't have it.
Yeah, fine.
One question.
Keep those. Meet those.
My brother has
Yeah,
two,
we can.
and then two regular goats, and then
Is everything?
two drinking goats.
Oh yeah, forget that.
I know, there's two there.
Oh, what the heck? I don't even know how they made it. Hey, so I have this goat YouTube channel, Carlson.
I'm sorry?
I have a YouTube channel that's focused primarily on my goats. And don't you have a YouTube channel focused primarily on livestock?
I do not have a YouTube channel of my own. So you have one on goats?
I do. And the funny thing about it is that like I don't touch it hardly ever. And maybe I'll post like a quick video when I'm there every once, like once or twice a month. And I post depositions. I post these hearings. I post ERD. I post everything on this other channel. And every time I get 25 new subscribers on the law side of things, I get 50 new goat subscribers.
You get 50 new ghosts?
Subscribers to the goat channel.
Oh, geez. All right.
You see what I'm saying? Like I'm chasing the dragon, but like every time I get close, it just like it runs away from me. You see what I'm saying?
So what's the name of your YouTube channel?
Deliberate Indifference, Wisconsin.
Delivering difference?
Mm-hmm.
So if I go in and just search for that, I'll find it?
Yep, Deliberate Indifference, Wisconsin. That's all you need. Bam. I'll send it to you right now.
Oh yeah, deliberate indifference. Found it. There it is.
I always get confused on the indifference part, but yeah. You got it. A little bit southeast Wisconsin focused at the moment, but we're getting there.
So where are the videos on the goats?
Oh, I didn't know you wanted that one. That one's called Peregrine Goats. Peregrine goats. There's the goats. There they are.
How long is this going to take them?
He was in transit back from the legislative building
Let's see.
to where he can appear.
Ben, Max just mentioned that we probably need to be careful with that one exhibit that has all sorts of confidential information in it. social security numbers, etc. I guess my thought on that, I don't exactly want to be the one who redacts all of that.
I can
information.
redact it. I have it mostly redacted.
Okay,
Copy already.
so why don't you send a redacted copy to the two of us? And I guess my thought is to have you take a look at it, Ben, and if you're okay with it, we'll just swap it out for the exhibits.
Okay.
Because I'm assuming all this is gonna be disclosed to the public at some point, so.
Oh, yeah. I would assume, I mean, I don't have any like PREA responsibilities. We don't have any responsibilities to these individuals at all. We have no duty to them whatsoever. So I'll take your word for it, Max, and let you deal with that. I'm all for protecting inmates, but I'm not going to spend my client's money on doing your job.
He's in the waiting room there.
Oh. Wrong mouse. Dan, can you hear us?
Oh. He'll be right back. He just ran out to throw some garbage away.
Yeah, Dan, can you hear us?
Yeah, I'm here.
Okay,
Yeah,
just hold on. We're gonna wait for Ben to get back here and then we'll take care of this.
Okay.
Okay, Ben, we have Mr. Grady back on the phone here. So Mr. Grady, you're still under oath from yesterday. And
Okay.
Attorney Hitchcock Cross will have a few more questions for you.
Okay.
Go ahead.
Great. You can hear me? Can you hear me?
Yes. Yes,
All right.
I can hear you.
Great. Did you ever call Miss Lavasseur a dog in front of Sheriff Brennan?
I never called Mrs. Lavasseur any name.
Did you call her a tyrant?
No.
Okay. Now, at any time, did you pass a budget that had the wrong information in it for the Sheriff's Department?
There was some information that for capital spending that was not included.
I can't hear your answer, sir.
There were some capital improvements that were not included.
Okay. And did Ms. Lavasseur bring that to your attention?
Yes, she did.
Okay, what was your response?
We'll figure it out.
And how did you communicate that response to her?
I don't remember.
Are you
Oh,
asking via email, in person? What are you asking?
That's right. What was the method of transmission?
I don't remember.
Okay. Now, what about her? Okay, was there anything else wrong with the budget other than the capital improvement issue?
Not that I know of.
Okay, and Ms. Lavasseur didn't make those, didn't inform you of any other issues?
No, she didn't.
Okay, about how many emails did she send you regarding the budget issue?
Couple.
When did this take place?
November. December.
Okay, what response did you make to those emails?
Hold on. I didn't hear. When did these emails occur?
November or December.
Of what year?
Last year.
22. Okay, go on.
Okay. So, and this is the same time that you're conspiring with Mr. Lindsay and Mr. Zupke to go around the constitutionally elected sheriff, right?
There was an ongoing investigation.
And the investigation was ongoing during the time that she alerted you to this waste, fraud, and abuse, right?
I wouldn't call it waste, fraud, and abuse.
Okay. And this, but otherwise, it's an accurate statement?
No, it's not. There was no
Oh,
conspiracy. There was no conspiracy.
I can't hear you.
He said
There
there's
was no
no
conspiracy.
conspiracy.
Oh, okay. Okay. But again, the timeline when you bypass the sheriff is the same time as Ms. Lavasseur alerted you to this, the issues with the budget, right?
I alerted Ms. Lavasseur alerted me in November or December of 2022.
Okay. Did you ever tell her not to attend any board meetings at any time?
Yes,
Why?
because she was a distraction, and we don't pay her to attend board meetings.
I didn't hear your first thing. She was a what?
Distraction.
A distraction.
Yes.
Okay, what kind of, how was she being a distraction?
Kept going on about the same thing over and over and over again.
Great, what were those things?
My jailers are not being paid enough.
Okay, why is that problematic?
Because they're the highest paid in the region.
All right, hold on. I didn't hear that one.
They are the highest paid in the region.
They are the highest paid in the region. Okay.
How do you know that?
Because I talked to other county administrators.
Okay, did you do a wage study?
Good.
Okay, and let me ask you that. Were they the highest paid in the region before they got an almost $2.50 raise or something else?
No, they were not.
Okay,
That's
so it was only
why we
after they
gave
got
them-
that raise, right?
Yes.
Okay. Now, who advocated for that raise? Ms. Lavasseur or somebody else?
Sheriff Brennan.
Okay, did you oppose that raise at any time?
I only opposed it not being able to pay for it.
So that's a yes, right?
I didn't hear the answer.
My only problem was, how do you pay for it?
Okay, and that was a supportive comment or something else?
Money doesn't grow on trees. We have it. We're in mid-year. There's not money in the budget. How do you pay for it?
Okay,
That's my problem.
I got it. And that's the budget, right, that you put the incorrect numbers for, right?
So the correctional officers got a raise last summer.
So that was another budget, not the one that was incorrectly passed, right?
That was yes.
Okay, and did you pass the budget containing the numbers for the previous year in 2022 or something else?
The numbers in 22 were based on the numbers my predecessor created.
Okay, can you answer my question?
I just did.
Were they the same numbers or something else?
I don't know offhand. I don't have it in front of me.
Okay, but you know they were based on what your predecessor did, right?
Correct.
Okay. And when Ms. Lavasseur alerted you to this problem, what steps did you take to fix the issue?
I said that we'd figure the problem out.
Did you figure the problem out?
Not yet.
Oh, okay. But it's fair to say you haven't figured the problem out, but you have terminated Ms. Lavasseur, right?
Yes.
Okay. Now, did you send an email to Mr. Kadat telling him that he could go to the committee board meetings, or sorry, the board meetings?
No, I told him he could go to the public property and law enforcement meeting.
Oh, okay. Why did you have send that email to Mr. Kadat?
Because he needed to introduce himself to the public property and law enforcement committee.
We already have that email. It speaks for itself. Let's
Sure.
on.
And have you ever told Mr. Kadat to stop attending board meetings?
Mr. Kadat doesn't attend board meetings.
Okay. Have you ever told him to stop attending any meeting?
No.
Okay.
He's
But
only
you
attended the
told
one
Ms.
meeting.
Lavasseur to stop attending board meetings, right? Because she was being disruptive, right?
We pay her to do her job, not attend board meetings.
Okay. And do you know that the constitutionally elected sheriff countermanded your orders and told Ms. Lavasseur to continue going to these meetings?
No, I did not.
Oh. Did you ever talk to him about it?
I don't remember.
Oh, okay. And this would have been Mr. Brennan, right?
Yes.
How about Mr. Zupke? Did you ever talk to him about it?
Yes.
When?
I don't know.
Can you try
I
harder,
don't
please?
remember. I don't remember.
Oh, well, was it since before or after you terminated Kim Lavasseur?
It was before.
Okay, about how much before?
Let's move
I
on
don't
from this
remember.
whole, hold on, stop. Let's move on from the meeting stuff because we've got the emails in there and I get what you're arguing.
I
get
got it. All right, fine. In the interest of time, sir, we'll move on here. So, you told us earlier that you had watched videos, right?
No, I did not tell you that.
Oh, okay.
I told you Detective Pierce watched videos.
And how did you gain information from Detective Pierce's, how did you gain information about Detective Pierce's report?
It was given to me.
Okay. And then, so did you see any videos or no?
No.
Okay. So you don't actually know what's on any of the videos, do you?
I saw the written report.
Okay. So that's what you based the written report on. And that's where you got the concept that there were sheets hanging up all the time? Is that right?
Yes.
Ah, okay. And are you the one who identified work rule violations in this report?
No.
Who identified work rule violations in this report?
I don't know.
Okay. How do you know which work rule violations were discovered in this report?
Because the report was given to me.
I didn't hear that answer.
Said the report was given to me. That's how I know.
Okay. How does that provide you with what information, what work rule violations were found to be violated based on this report?
I don't understand your question.
I asked you before whether or not there were any work rule violations contained in this report. What's the answer to that?
In the actual report from Detective Pierce, you have to be more specific, sir.
I don't. Are you able
Yes,
to
you do.
identify any work rule violations in the 50-page report from Mr. Pierce?
Personally, no.
Okay. And you never discussed any work rule violations from the report on Mr. Pierce with anybody, did you?
I talked to the chief deputy.
Okay. While he was the chief deputy, right?
Yes.
Okay.
And while he was sheriff.
Oh, okay. And what work rule violations were identified while he was sheriff?
It's all in that document. It's posted on our website.
And he told you and identified each one of those prior to you terminating Ms. Lavasseur, is that right?
Yes.
Okay. How did he do that?
Orally.
He orally told you about each one of these rule violations, is that right?
Yes. Yes.
Oh, okay. And when did this occur?
January.
Okay. And did he tell you that he had spoke to Kim Lavasseur about that at any time?
He did not tell me.
Okay. Now, when you heard of these rule violations, what steps did you take to discover whether or not the rule violations were based on any actual rules?
I talked to corporate counsel.
Okay. Did you look at the rules, the rule book?
No.
No. Okay. How did you know? Because we've had testimony that the rule book that you've cited in your response to her grievance was in fact not in effect at the time that you terminated Ms. Lavasseur and hadn't been in effect for some years. Is that true?
I don't know anything about that.
Okay, so you don't know which actual rule book was in effect at the time when you terminated Ms. Lavasseur, do you?
I rely on corporate counsel.
Okay. And when was that?
January.
Okay. So it's fair to say that you relied on Mr. Zupke for the alleged to identify the rule violations. Is that right?
Yes.
Okay. And you had Mr. Lindsay check whether the rule violations actually existed. Is that fair?
Yes.
Okay. And then he reported to you that those rules were in fact the rules that were in effect or something else?
Yes.
Okay. So based on that information, you decided to terminate Ms. Lavasseur. Is that fair?
Yes.
Just 1 second, if you please. Thank you. What board members did you tell, or I guess county board members, I don't know if it's a county board or what you have there, but did you tell about your decision to terminate Ms. Lavasseur?
At what time period?
Great. Prior to terminating Ms. Lavasseur.
I told our county board chair.
Okay. How about after?
After I told most of the county board.
You tell all of them?
Well, I sent them all an email telling them.
Okay. Have you told all the board members about the problem with the budget?
No.
Why not?
Because we haven't figured out a solution yet.
Okay. Is that why you didn't respond to Ms. Lavasseur?
I told her we'd figure it out.
Okay. And it was at a face-to-face meeting?
I don't remember.
Okay. Did anybody else witness this interaction?
I don't know.
Okay. And again, this would have taken place within the last, no later than November of 2022, right?
All right,
Right.
let's start moving on from the budget. I understand your argument. I get that there's an issue with the budget is brought to Mr. Grady's attention by Ms. Lavasseur. There's no solution. The rest of the county board hasn't been advised of it. I get it.
Okay. And that's, in fact, you no longer have the problem with Ms. Lavasseur going to county board meetings after you terminated it, right?
I don't. She can do whatever she wants.
Okay. Does she still have access to the budgetary information?
The public document, I'm assuming she does. Let's move on.
Okay. Is that accurate? Go. All right. So if the rules that the inmate rules that are cited in the response to the grievance are not the actual rules that were in effect at the time, the decision to terminate Ms. Lavasseur was based on factually incorrect information, right?
This is the first time I'm hearing about that, so I can't answer that question.
Okay, well, if you accept it's true that those rules are not, were superseded by the ones that are actually submitted on Signet, then you would have terminated Ms. Lavasseur based on false rule violations, right?
If don't see what you're seeing, I can't answer your question.
I didn't understand what you said.
I can't answer your question. I haven't seen what you're talking about.
Well, and I'm going to cut you off here because there's been no showing that that 50-some page rule book is no longer enforced.
There's been 5 showings. Sergeant Wilbur said.
Stop. There was testimony that it was the paper copy was on every jailer's desk.
No.
There was testimony that the smaller one was on some computer system.
It's simply inaccurate. What the testimony was is that not the smaller one, but the updated one, the gray one that we're all talking about, is what's on Signet. The testimony was also that all inmates are required to look at it before they can sign out for commissary, have visitors, and make calls.
Right.
Testimony, excuse me, was also that the staff members are all aware that that is the definitive policy because they are required to make sure that the inmates know about it. For why? Because the district attorney requires that. Because they don't want to have rule violations prosecuted without a confirmation that the inmate is aware of what the operative rules are.
Correct. But there's been nothing showing that the 50-some page book is no longer in effect.
Well, except the revision date, except for the revision date.
But nothing in that says that the other part's invalid. I understand what you're saying. I get it. It's not clear. And why there's 2 of them, I have no idea.
Right. And Mr. Wilbur said unequivocally that the policy that was on Signet was the definitive policy. Ms. Lavasseur said definitively that the policy that was on Signet is the policy. Mr. Lindsay, and acting his capacity as both a witness and advocate, testified that he wasn't clear. But there's no evidence on the record to support that the fact that these 2 things are on 2 different desks, and you're really stretching there to say that a revision date doesn't mean that the previous one is out. Again, you had direct testimony from Mr. Wilbur that they do not use that one. Again, he identified it by the badge insignia and the statement on there. And the reason he did that is because it's all digital. And that's why. So it may be the case that Mr. Lindsay didn't know that at the time, but that doesn't make it any less so. I know he's testified quite a good deal here today, but nevertheless, it's the testimony, there's no doubt, and as uncontroverted, that document that they submitted as the jail rules, which are linked and identified in the grievance response, are no longer active. Mr. Wilbur was unequivocal, and so was Ms. Lavasseur. The fact that there was updated ones available, again, his point and position was clear that the inmates are the ones who received those rules, And those are the rules that the way that the sheriff's department verifies that they've received them is because they're ineligible to get commissary letters or communications or visits without verifying that they got those rules. And he testified that that was the training and the practice of the staff there. So that's quite a stretch.
Okay, what's the next question for Mr. Grady? Let's finish it up.
Okay. Let's put it like this. Do you have any reason to believe that the revision date at the bottom of the jail rules from Signet do not indicate that that document has superseded a previous document?
I don't know what you're talking about.
Do you know what the purpose is for revision dates on county documents?
I have not seen the document in question, therefore I cannot answer your question.
No, I'm sure you can. Do you know what a revision date is, sir?
I cannot answer your question without seeing it.
Do you know what a revision date is?
Yes, I do.
Okay, what's the purpose of a revision date?
You revise the document on X date.
Okay, so that would mean that prior to that date, that any versions of that document are no longer definitive, right?
Not necessarily.
Oh, what else can a revision date mean?
I don't know. I haven't seen the document you're talking about, so I can't answer your question.
Well, can you give another example of what a revision date could mean?
Again, I have not seen your document.
I appreciate that. Are you able to answer the question on what a purpose of a revision date is or not?
I just told you. To show you
that without seeing the document, you're unable to explain.
Stop it. Now you're cutting him off.
Explain to us?
Let him answer. He's already answered. He doesn't know he doesn't know the answer. I get your argument. I get it. And I'm quite honestly, I don't know why it wasn't asked of the sheriff which rules actually apply. Neither one of you asked him that.
Well, because we got it from Mr. Wilbur and we got it from my client. That's why.
Next question.
This is, and I want to be clear, you're bound to accept the evidence that's put in front of you and to weigh that, not things that could have.
I'm well aware of what my responsibilities are. Next question.
Okay. So when was the last time prior to Ms. Lavasseur being terminated that you had a face-to-face conversation with her?
No.
Okay. And again, did you ever have a conversation with her in which you discussed any potential rule violations?
No.
No. Okay. And again, the sheriff was the one who identified these rule violations to you, but then you went to Mr. Lindsay to confirm that those were the correct rule violations, and then he confirmed that those were the correct rule violations, right?
I depend on corporate counsel.
All right, I don't have any more questions.
Anything?
Yes. Dan, did you ever tell Ms. Lavasseur that she could not go to a PPLE committee meeting?
No. He was expected to go to those meetings.
Did you terminate Miss Lavasseur because she raised questions about the county's budget?
No,
Nothing further.
So is something going on I'm not aware of or what?
No, he said nothing further, so we're back on redirect if you had anything.
All right. You don't have any questions?
No.
Okay. Were you aware of how old Miss Lavasseur was when you made the decision to terminate her?
Objection to being outside of the scope of redirect.
Sustained.
Well, you just asked her if she terminated him, if he terminated her because of that. Let's be done. I think we're all clear here. We've got nothing more for you.
Okay, Mr. Grady, you're free to go. Any other witnesses, Mr. Hitchcock Cross?
No.
Any witnesses from the county?
No, Your Honor, no more.
Judge.
Oh,
All right.
sorry, no, Mr. Carlson.
So we are at closing arguments. Let's keep them short. I know, I mean, if there's technically a 10-minute limit, but if you go a little bit over, that's fine, but let's keep it short, huh? I think I kind of already know everyone's arguments here on both sides, so. So, Mr. Hitchcock Cross, if you want to go.
Well, we've got the burden here, so.
Yeah, I would go first.
Oh, yeah, you do. That's right. So, Mr. Lindsay, you go first.
Yes. So here is the county has to follow the employee handbook in the termination grievance procedure. Standard in that procedure, standard for the county employees for termination is whether that decision to terminate was rational. The employee handbook clearly states that there's no protected property interest in an at-will employee's employment. The Ashland County Sheriff's Office custody and control manual policy specifically states that those other protections in that policy do not apply to at-will employees. All the testimony today is that Ms. Lavasseur, as jail administrator, was not a protected employee. She was an at-will employee subject to the general employee handbook and termination provisions therein. Means the county needs a rational basis to terminate her. County provided and had that rational basis. All the testimony showed there are numerous rule violations by inmates in the jail on Ms. Lavasseur's watch. Following those rule violations, there's a serious incident of sexual assault between inmates, alleged sexual assault between inmates that occurred. And there was lack of follow-up and acceptance of responsibility. Also seemed to be a lack of communication and trust in the power structure between, or the chain of command within the jail and the sheriff's office. That is a rational basis. The sheriff who can't trust his jail administrator to run the jail because that jail administrator can't uphold the rules is a rational basis. the sheriff testified that also, since Ms. Lavasseur has been replaced as jail administrator, those issues have stopped and control of the jail has returned and there aren't the further issues. That is a rational basis. Ms. Lavasseur's attorney seems to be making arguments and points that for it to be a rational basis, Mr. Grady had to have himself interviewed everyone involved and himself witnessed every basis for this decision to terminate. That is simply not the case. Mr. Grady relied on the work, the investigation, and the opinions of other Ashland County employees. He didn't make this decision without consulting anyone. He didn't make this decision without relying on someone's opinion who has reviewed this evidence. Also, this isn't a case or an issue where the reasons for termination were trumped up after the case. The recording of the January 19th meeting between Ms. Lavasseur and Brian Zupke clearly indicates that they had spoken about the same issues that they spoke about that day, a week or so previously. In that meeting, Brian Zupke clearly tells Kim Lavasseur the reason for the employment decision was her failure to maintain control over the jail, which resulted in these sexual assault allegations, and also her failure to follow through with the necessary chain of command. Ms. Lavasseur, in that meeting, didn't take responsibility in her response to the grievance. She doesn't take responsibility for this control. She instead seemed to question, and her attorney questioned over and over, placing the importance that the sheriff and the deputy sheriff were in control and responsible for anything that happened in the jail. But according to the statements presented by Detective Pierce, Ms. Lavasseur previously said it was a sergeant's responsibility for that. So it seems to be everyone's responsibility except Ms. Lavasseur's here. Those are, in that information, in what is presented, everything that was considered by Mr. Grady, Brian Zupke, and Brian Zupke in making this decision, relying on those other employees' investigations and opinions, serves that rational basis. Now, Ms. Lavasseur's attorney has raised several issues with the potential for standard of review or other legal standards that apply here. In his pre-hearing statement, he cites several cases that apply the Loudermill standard. There's simply no law requiring that standard to apply. It's the standard that's in the Employee Grievance Act 10 eliminated that standard of all of the Loudermill requirements. The cases that Attorney Hitchcock-Cross cite to are all for employees who were covered by or were protected employees and were not subject to the Act 10 revisions to the Loudermill requirements. And rather the corollary case in Mars, while not controlling, is the standard that applies. The allegations also that there's some vast conspiracy going on in Ashland County here are just, quite frankly, off the wall and completely unsubstantiated. And I don't think merit any more response. So that the county just states that all of these things, all the evidence presented together show that this issue was considered. There are investigations, it was looked into, it was thought out, and that decision was made with a rational basis. And that's all the county will say.
Thank you, Mr. Hitchcock Cross. You're muted.
So I think it's all clear to everybody in this room that there is basis for sex discrimination against the county. I think there's clear that there's basis for age discrimination against the county. I think there's basis for all sorts of clear law violations, including evidence of waste, fraud, and abuse, are all more likely reasons that the county acted as opposed to what they claim to be the reason. Now, we all know that it's garbage based on the county's own documents. The county can't keep its story straight. Mr. Zupke claims to have fired Ms. Lavasseur twice on his own authority. Mr. Grady claims to have terminated her once on his own authority. And again, there's some disagreement between Mr. Zupke and Mr. Grady as to who actually terminated her. So we wonder how Ms. Lavasseur is supposed to know. There's also clearly false statements by a member of the bar regarding this case. His own testimony was that he told her he didn't know, and he obviously knew. He made those statements under oath to a member of the public, and that is indication of a serious lapse of ethics. There are others. Again, he's appeared here today as both an advocate and a witness. He's testified, not just in his role as advocate, but he's actually testified. That, of course, is going to confuse the tribunal as to what his role is as a witness or an advocate. It's going to be difficult, and my client is prejudiced here because we don't know if what he's saying is advocacy or what he's saying is fact. And again, he's taken time and time again to intersperse his version of the facts into this hearing as much as he possibly could. Again, and we've seen that been translated into the hearing examiner, who, for example, seems to accept Mr. Lindsay's statements, for example, on the revision date. There is other just going on of evidence of bias here in terms of how this hearing has been conducted. I point out that Mr. Lindsay just referenced a case that while I was arguing this and examining a witness, the hearing examiner put before me and then asked me to interrupted the case, interrupted my train of thought, interrupted the witness, and asked me to review a district court case, which then my learned colleague over there just told us was both not controlling and the law. And that's basically their entire argument. They're going to have it both ways. They're going to have it both ways. They're going to have her work herself to the bone and then throw her out because she's advocating for more pay on behalf of the correctional officers for safety. We've heard testimony that there's an illegal conspiracy here by Mr. Lindsay, by Mr. Grady, and by the then chief deputy to bypass the elected sheriff of the county. We've also heard testimony several times from Mr. Zupke and Mr. Grady, and that's, I think, the one thing they can agree on is that Ms. Lavasseur supposedly didn't tell Mr. Zupke, but she did tell Mr. Brennan. Well, that's false. And Mr. Zupke, the only thing he knows about the sexual assault allegation is that he didn't know anything before 11/29. And even when we confronted him with that email that he got 2 weeks later, he said he wasn't able to talk about, to identify what that meant. He also said he took no steps to find that out. We've got testimony from Mr. Wilbur that he told him. We've got testimony because he put the policy on his desk, and there was no further comment from Mr. Zupke. We've got testimony that he wasn't there. Mr. Zupke wasn't in his office when he was in charge of the sheriff's department. And when these allegations came out, he wasn't there. Ms. Lavasseur was there, but he wasn't there. So she, instead of having, once again, she has to clean up his mess, and she waits till the sheriff comes back, and then she starts doing what she needs to do. Because why? Because Mr. Zupke couldn't be there because he was too busy electioneering. Well, whose fault is that? We heard, and when you listen to the tape, you're going to hear what the primary concern is, because we heard that time and time again. It's the other thing they can agree on, I guess. Liability. They're afraid of liability. Don't say anything in this rules about liability. And whose liability are they really worried about is the sheriff, and pretending like the sheriff didn't know. And I don't think that took us more than 5 minutes to crack that and to prove that he actually did know. Because he knew at least on the 15th, if not earlier, and he sure had every duty and reason to know, but he didn't. So again, the person who was asleep at the wheel is the sheriff. And we submit blaming Ms. Lavasseur for the man's failures is just another form of sex discrimination. We also point out that Mr. Cadotte and Mr. Pierce knew that Ms. Lavasseur was being terminated, but Ms. Lavasseur didn't know. And I just want to go back here because Hayward and others is not only just positive, it's about a municipal court, municipality. It's not about a county, and it's certainly not about a grievance procedure that's under the statute. I'll also point out that this grievance procedure is a property right. It absolutely, why do you think we're here? For the fun of it? No, because Ms. Lavasseur has a statutory right to have her employment reviewed. So you can say at will all you want, but that doesn't mean it's at will, because it's not. And as soon as you admit that it's not at will, then she's got all of her Loudermill protections. And that's exactly what's going on here. Her right to this job cannot be taken from her without this hearing. It says it right there in the statute. The policy also is clear. So is the grievance manual. Making faces at the hearing examiner during my closing statement is not very persuasive, and it's certainly on the record, Mr. Lindsay. The point is that policy says that unless modified by statute or other rule, well, it's modified by statute. Again, she can't be terminated without this grievance process, and that gives her due process rights. That gives her a property interest. And that's clearly what you all have missed and have disrupted this hearing. And of course, tried to put on this is the same as if you were bringing a circuit court case forward and trying to hold that out against an appeals court, a Supreme Court case, as if that was binding. You all know it's not. You knew it wasn't when you sent it to me. You knew it wasn't when I told you that afterwards. And nevertheless, you continue to make rulings based on that incorrect assumption of the law, which again, you knew was not right. Just like Mr. Lindsay should have known what were the actual rules in place at the time when he cited them after the fact. Because again, there's no document or any evidence at all that shows, we asked Mr. Grady just a few minutes ago to show us where there was any rule violation that was shown to him. He couldn't do it. He says he relied on Mr. Lindsay to give him the right information. Well, he didn't get the right information. We can all see that right in there, that all you have to do to show Mr. Lindsay to be a liar is to compare the letters, Mr. Lindsay's statements under oath, this goes for Mr. Grady and Mr. Zupke as well, and the response to Ms. Lavasseur's grievance. The letters, the January 27th determination, the January 19th demotion, again, they don't even know. They're not able to clearly articulate a point in time at which Ms. Lavasseur was terminated. It can't be rational because they don't even know. Again, there cannot be evidence of sifting or winnowing if they haven't actually bothered to find out what actually happened, to find out what rules were violated. And what he's trying to say is, Mr. Grady needs to be able to point to a decision that he knew and he made that's rational. He wasn't able to do that. All he said in his testimony throughout the entire time was look at the response to the grievance. Well, that's ex post facto. Again, there's got to be some evidence of sifting and winnowing. That's what the standard is. It can either be not based in reason, meaning you cannot point to any legitimate reason to make this decision, or there can be no evidence of sifting and winnowing. And to be clear, on the side of unreasonable, just standing on its own, all of these false statements made by the county administrator, Mr. Lindsay, and Mr. Zupke show that they did not use any sifting and winnowing or any reason. Because if they had a reasonable answer, they wouldn't have to lie. But that's what's going on here. They wouldn't have to lie about bypassing the sheriff. Because they did do that, and it's illegal. The sheriff is the one with the constitutional duty over that jail, not the county administrator, and certainly not the chief deputy, and certainly not Mr. Lindsay. And they knew that, which is why they chose to wait until the sheriff had left in order to enact their plans against Ms. Lavasseur. We've heard testimony that the county executive has had it in for Ms. Lavasseur for quite some time, that he called her a dog and a tyrant, and he himself testified that he told her not to attend these meetings because she was continually asking for a pay increase on behalf of her subordinates. That's his testimony. Now, again, going to these letters where it says termination, termination, and when you look at the decision here, even this letter here says in the response to the grievance filing says that she was terminated in response to the meeting. It said Lavasseur left the meeting with Sheriff Zupke without providing any response as to her intentions on continued employment with the county. After this meeting, it was concluded that the trust between Lavasseur and the sheriff's office could not be regained. As a result, Lavasseur's employment with the county was terminated since she had not accepted continued employment as a correctional officer. You cannot accept that statement and also accept the argument put forth by Mr. Grady that he was the one who terminated Miss Lavasseur and that she was entirely terminated back on the 19th. Those two statements are mutually exclusive. That's the problem. There's more in there. There's a lot more in there that contradicts it. There's the fact, again, that Mr. Lindsay made false statements. What he testified under oath was not the same as what's in this response. So again, that's the problem, because they're basing this whole, their justification is supposed to be what's in this response here. This ex post facto argument that they made justifying their termination. And again, this is Dan Grady's name who's authored it. He said it's all true. Well, you can't accept that what Dan Grady authored on February 16th, and you can't accept what he testified under oath as being true at the same time. Because they're not. Again, you can't have terminated her twice and have terminated her once on the 19th. That's not accurate. That's no version of reasonable allows somebody to have three different versions of how my client is terminated. Three different versions. They even play games with, was she terminated? Did they rescind the offer? They don't know. And yet they sit here and try to claim that Miss Lavasseur somehow is acting frivolous and supposed to know what exactly is the reason that she was terminated when they themselves do not know and could not come up with a coherent story in front of you today and yesterday. Mr. Zupke contradicted himself time and time again. I don't think it was 2 minutes between contradictions. Mr. Grady flipped out and admitted that he was alerted by Ms. Lavasseur of these budget problems, which is also simultaneously the same time when Ms. Lavasseur is told not to go to these meetings and started having a problem with the deputy sheriff, new sheriff-elect, Mr. Zupke. That's not a coincidence, and you know it. And you know it. So we'll leave that to the public to decide the fate of Mr. Grady, Mr. Zupke, and Mr. Lindsay here, because they will have a chance to review this, and all this will be made public. But in the meantime here, again, it's quite clear that their story is false. 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 They cannot show, I mean, even if you're to accept your argument, sir, Mr. Examiner, that there is unclear testimony as to what is the actual definitive rule violation, you have to accept that there's at least two, or that it's unclear, which you appear to have done, even though that flies in the face of the evidence. That's still problematical. Why? Because if you have two sets of rules and they don't follow and they don't track each other, then they're just picking one set to go after her. That's not reasonable. Because even here, the question, just on reason, is whether or not their story even holds together. And it's quite clear that it's way more likely than not that it's sex discrimination, age discrimination, race discrimination, retaliation for free speech and other activities. We've all got that on the record. That's all very clear. I'm sure we'll be dealing with that later. But again, the story they've concocted does not hold together. It holds water like a paper bag. And the citizens of Ashland County are going to learn that soon enough. They're going to know that there's a hole in the budget that Mr. Grady hasn't fixed yet. They're going to know that Ms. Lavasseur is the one that reported it. They're going to know that Ms. Lavasseur saved 8 people's lives, and that they're going to know that within a week of her leaving, somebody dies for the first time under Mr. Cadot's watch. They're going to know that Mr. Cadot is making more money, that he's a younger male of a different race, and the same race as the putative decision maker. They're going to know that Mr. Zupke's testimony and Mr. Grady's testimony are mutually exclusive, let alone when compared to Mr. Sergeant Wilbur and the sheriff. They're going to know that people wanted to testify here were too afraid of retaliation to do that. They're also going to know that Mr. Wilbur specifically said that he was afraid of retaliation and that he expected that he would be retaliated against for telling the truth at these proceedings here. They're going to know that Ms. Lavasseur did everything that she could have and more to take the county through a difficult time when her predecessor shot himself, taking them through COVID, and even in the face of Mr. Zupke, as we had testified, trying to reopen the jail, kept the jail COVID compliant because that was the recommendation of the health department in Ashland County. And just like the little prince, Mr. Zupke said, you wait. Just you wait till I've got my big boy pants on and I'm in charge. He didn't wait long. He waited some 16 days. Some of that he's probably doing other things. But it was clear that it was Mr. Grady's, Mr. Zupke's, and Mr. Lindsay's goal to remove Jan Lavasseur, Kim Lavasseur, for reasons other than that they concocted. Because again, not only is the testimony clear that that's what happened, but their own decision and justification doesn't hold water. The letters contradict the response. The statements to the papers contradict the response. Mr. Lindsay's testimony under oath contradicts the response. Mr. Grady's testimony under oath contradicts the response. Mr. Zupke, at least, has a better, let's say, fact pattern behind him. And he is at least clear that Ms. Lavasseur is terminated twice, which the letters state. They give no reason until after she files this termination, and they hang their hat on this conversation that they had to discuss her continuing employment. Well, you all know that that's nonsense. You know what the real reason is, but you don't even have to say that. That's what's nice here. All you have to do is just point to the fact that Mr. Lindsay's statements under oath and the letters that he wrote do not accord with each other. They are mutually exclusive. We're not getting much beyond Aristotelian logic here. Something cannot be and not be at the same time. So it cannot be that she was terminated by Mr. Grady before the 19th and also terminated by Mr. Zupke. It cannot be that she was terminated by Grady on the 19th and also terminated by Mr. Zupke the morning after the meeting, which is what his testimony was. Cannot be that Mr. Grady terminated her and Mr. Zupke terminated her. So for them to say that Ms. Lavasseur should know what it is that she's being disciplined for, when the county can't even identify when or how it disciplined her or terminated her, that's unreasonable. Now, just going a little bit further here, again, as we put in front of you, the actually binding case law is that both Loudermill apply, but also this definition here that I think you were very clipped in understanding is that not only does irrational mean that there is no basis, but it also means there has to be sifting and winnowing. That means that they have to have some kind of conception about possible alternatives, to have evidence of some kind of rational decision. Right? That's the exercise that you, Mr. Examiner, are about to have to do. You're going to have to show a rational basis for your decision. That's sifting and winnowing. You're going to have to compare the evidence that was in front of you. You're going to have to compare what Mr. Zupke said, what Ms. Lavasseur said. You're going to have to compare the fact that Mr. Lindsay's 3 witnesses contradicted each other time and time again. You're going to have to admit the fact that Mr. Lindsay contradicted himself time and time again. That's sifting and winnowing. You're going to have to determine which is the right, who actually terminated Ms. Lavasseur. Who's got that power? You're going to have to figure that out. You're going to have to figure out who and what was the real reason. Or not. Because if you can't identify a legitimate reason or evidence of sifting and winnowing, then she wins. So the problem with evidence is it can't just be pick one. I'll pick the time that Grady says he terminated because I like that one better. No, I'll pick the one where Zupke says he wakes up in the morning and decides to terminate her because of the meeting. I like that one better. And oh, it also fits in with on January 16th. No, I want to go with the letter from January 27th because I like that one better. You don't get to do that. That's the problem. Because that's what the county did. They terminated her first, and then they sought to justify it afterwards. And anybody who's going to watch this is going to know that that's what happened. And you know that that's what happened, because that's what happened. Because the evidence in front of you that you're going to have to sift and winnow through is very clear. Ms. Lavasseur's testimony, Sergeant Wilbur's testimony, Sheriff Brennan's testimony, all accord. Mr. Zupke's testimony, Mr. Lindsay, the advocate / lawyer, Mr. Grady, and again, Mr. Grady's testimony just from yesterday to today is 2 different things. Yesterday, he says, look at the video, sheets. Today, he didn't see any talk about any video. Well, we've got the tape, so we can check that out. But I recalled it, you recalled it. That's why we called him back to ask these questions. But hey, just like Mr. Lindsay, the advocate / witness says, there's no grand conspiracy here. Well, there sure is a lot of sloppiness. There sure is a lot of failure to have the story be straight. There sure is a lot of failure to actually do what it is that they have claimed to have done, because they can't show anything that demonstrates any kind of sifting and winnowing. And we've asked them for it. We've asked them for we've asked them, put them under intense interrogation. And the best they could say is, Mr. Zupke now, and this is on day 2 here, told him, gave him the rule violations orally. Well, when we go back to Mr. Zupke's testimony, it's to say when the Facebook audience, when the YouTube audience goes back to Mr. Zupke's testimony and they compare it to Mr. Grady's testimony, and of course, Mr. Lindsay's testimony, we're all going to be able to see who said what. And I think that's the important thing here, is that the people of Ashland County need to know, and they will know, that Mr. Grady, Mr. Zupke, and Mr. Lindsay all conspired to terminate Ms. Lavasseur without the knowledge of the actual constitutionally elected sheriff, and in the face of Ms. Lavasseur's comments, pleas, and other activity to try to get her staff the support that they needed. And even when Mr. Grady admits that he tells her all this, what happens? But Mr. Brennan says, you keep going. Okay, well, that was bad. But it wasn't until, and could not be a coincidence, that the moment she tells Mr. Grady about his failure on the budget that he still hasn't fixed yet, that steps are in motion, and there's 10 conversations between Mr. Grady and Mr. Zupke discussing allegations against Ms. Lavasseur that were never shared with the actual sheriff. So really what's going on, and we've heard this 3 times, that Ms. Lavasseur was keeping things from the deputy sheriff. Well, in fact, it was Mr. Grady, it was Mr. Lindsay, the witness cum advocate, and Mr. Zupke, who were keeping things from the sheriff, the actual person who was elected by the people of Ashland County to protect the jail. We also heard testimony from Mr. Brennan that she was doing a fantastic job. And once again, she, in a year and a half, saved 8 lives. Mr. Cadet, who is younger, who is a male, who's getting paid more, much more. And again, he's not doing 2 jobs. No, the woman cleaned up the mess. She identified the problem. She was kicked out the door, and now they put a younger male in there and paid him more money. And what happens? Within a week, he kills somebody. Now, we all know what really happened. But once again, you don't have to go that far. All you have to do is point to the February 16th document, the January 27th document, the January 19th document, conclude that they are contradict each other, they are mutually exclusive, cite to Aristotle, and you're done. There cannot be mutually exclusive versions of her termination and this termination being upheld as reasonable, let alone any evidence of sifting and winnowing. And you know it. And you know it. So, with that in mind, again, it's all coming out. And there will be repercussions for all of this for the people who acted against the interests of the county. But again, all you have to do is find that you don't have to call them a liar, even though they are. You don't have to say that they're covering up for waste, fraud, and abuse, or that they're discriminating against her on the basis of her sex, gender, and national origin. All you have to do is conclude that they're mutually exclusive and call it a day. We submit that you should do that, and you should award her a job back and back pay, because that's the only reasonable thing to do here, because it's impossible for you to cite February 16th, January 9th, 19th, January 27th, which really was January 30th, by the way, and and take those facts into consideration and find that there was a reasonable decision here. Because the county's own words show that they were being unreasonable. They didn't sift and winnow, and their own justification is false. A false justification is unreasonable, no matter how pretextual it could possibly be. That's the standard. That's the law. And again, we really need to underscore here how prejudicial this hearing is and was, and how damaging it was to have that uncontrolling case be brought up in the middle and then cited as an authority, and then make rulings based on that. We all know, all the lawyers in this room know that that district court is not binding. That's just her opinion on the facts surrounding those two claimants and nothing more. And you know that. So, thank you for watching Ashland County. We certainly appreciate it.
Anything else?
No, thank you.
Okay. Little housekeeping. I think Attorney Lindsay was going to redact the portions of the sexual assault report so that we don't have names out in the public domain. And then we're also going to get a cleaner copy of the jail rule book, which I believe was Exhibit 16. Nope, it's Exhibit 12.
The SIDNET jail rule book, right?
Exhibit 12. It's called Ashland County Jail Rules and Regulations.
Okay, is that the one that's up on SIDNET or the other one?
SIDNET.
Okay.
Okay.
When will this copy of this video be available?
Well, I guess here's my thought. You're going to come here on Monday to put it into Dropbox.
Yep.
And then it'll, I guess, go out to you via Dropbox.
Monday would be fine.
And then what you do with it from there is your prerogative.
I wonder what could happen.
Okay. Anything else? Otherwise, we'll wrap this up and call it a day.
Absolute pleasure meeting both of you.
All right, thank you. We'll end the recording.